All right. How's everybody doing tonight? It's about 9:30 p.m. West Coast time on Wednesday. I think it's Wednesday, September 3rd, 2025. This video is going to be a bit longer than most of mine. We're going to talk about some law tonight. We are going to talk about defamation, and we're going to talk about chorus. And we're going to talk about a video that was put out earlier today, I believe, earlier today or yesterday by David Pakman of the David Pakman Show. He put out a video, it's about 10 minutes long, about whether or not he is going to sue Taylor Lorenz and Wired for defamation. And the video is titled Lawsuit for Defamation ? Spoiler alert, that's a question. It's not a statement, and the answer is no, for reasons that we're going to talk about herein, reasons which David Pakman did not mention in his video. To briefly kind of recap his video, he said, I don't want to open a video or a show this way, but I have to talk about a defamation lawsuit that he's not filing. And he talks about the article that Taylor Lorenz wrote and published a week ago, last Wednesday morning. He said it made multiple untrue allegations and implications about him. That he's taking money and that for creating content, and that Chorus has control over his content. My best recollection of the article is that it made no allegations about David Pakman specifically, that he was taking money, and it made no allegations specifically about him that Chorus had control over his content. As it relates to taking money and control over content, the article itself referred to the terms of the contracts that the 90 or so cohort members, creators who were going to participate in this program, was the terms of the contract that was offered to them. And so he went on to say that multiple of his followers and subscribers said, you should sue for defamation. That's the way you take back control. And his followers are correct on that. If there is a case for defamation, in this instance, there is not. And we'll talk about that in a moment. He went on to say that there's no story here relative to Taylor Lorenz's article. I did a video the other night where I said that the attorney, who I think his name is Graham Wilson, he works for the Mark Elias law firm. I love and have a deep, deep, deep respect for Mark Elias. He went 60 wins, 1 loss against Rudy Giuliani in lawsuits following the 2020 election. Mark Elias is the real deal. I mean, he is absolutely the real deal. He is someone, dude's just a badass. He is. But relative to the article, David Pakman said that a lot of people have realized that there's no story here, which I found to be a bit curious. And he said that more people see the story and the allegations in the original article than they do see the corrections, which I also found to be curious, because there have been no corrections to Taylor's article. There have been a couple of additions from that attorney, Graham Wilson, who represents Chorus. There haven't been any corrections. And the editor's note doesn't say that there are corrections. It says there are additions to the article. And then he goes on to say that a lot of people in response to this article have canceled their memberships and subscriptions. It's 2025. As far as I know, David Pakman started his YouTube page 16 years ago, in 2009. He has somewhere between 3 to 4 million subscribers on his YouTube page. A few people canceled their subscriptions. Okay. He went on to say that, people are of the belief, I think, that based on the article, the DNC is telling him what kind of content he can make, and that Chorus is telling him what kind of content he can make. The article doesn't mention the DNC. He mentions a bunch of other kind of timeline misrepresentations, I think is fair to say. But I don't believe the article ever discussed his specific contract with Chorus. And he's not signing on with Chorus as somebody who's got 50,000 followers and needs help, who needs mentorship. He's David Pakman. He's been doing this for the better part of 15 years. He has between 3 to 4 million subscribers on YouTube. But he didn't tell us what his contract is. He didn't show us the terms of his contract. He didn't tell us what he's being paid for by Chorus, if he's being paid at all. But he's not coming into Chorus as somebody who doesn't have a platform. I think that's clear. I think he would even agree with me on that. And he went on to say that, because of the injustice of all of this or something, that his followers and subscribers are telling him. He went on to say that many of his followers are telling him, in a sense, the sense that I got was that the only way that he could restore his credibility with them and the subscribers that he lost is if he filed and won a defamation lawsuit. Otherwise, these folks are going to think that all of the allegations are true. The allegations that are made in the article, none of which have been proven or demonstrated through documents to be untrue 8 days after the article has been published. Then he said that the article is very misleading. He did not say that the article was false. He did not say that anything in the article was false. And he said that some people went further and made further allegations outside of the article, which you can't sue Taylor Lorenz for defamation based on things that other people said after the article came out. And then I think the most disturbing thing, he pretended to not know how to pronounce AIPAC. He said AIPAC, IPAC, AIPAC, IPAC. I don't know how you pronounce it. Be for fucking real, dude. You've been doing this for almost 20 years and you don't know how to pronounce AIPAC? You should see the comments on his video relative to that point. They are not flattering. He said maybe they're getting funding from AIPAC, not in the article. Maybe they're getting funding from the DNC, not in the article. He said he's had some canceled memberships. He has roughly 4 million subscribers. He lost, according to him, roughly 6,000 subscribers, but he gained approximately 5,000 subscribers. So that means a difference of 1,000 subscribers relative to 4 million subscribers. 1,000 lost. That's less than 0.1%. Not super strong in the damages department. He went on to say that he had consulted with multiple of the top defamation attorneys in the United States. And I think correctly he said that those kinds of attorneys, I'm a civil litigator myself, I have been for almost 27 years, that attorneys in civil cases typically discourage litigation. That's 100% accurate. But he spoke with the best, according to him, the best defamation attorneys in the entire United States, and they discouraged him from litigation. And then he went on to list several reasons why, but he left out, I think, the most important one, which I'll come back to in a moment, which is the actual meaning, what you have to prove when you sue a reporter and a news outlet for defamation. He didn't talk about that at all. And I'm going to talk about that at length here in a moment. He said he's undecided as to whether or not he's going to file a lawsuit. He said, if I win, I can clear my name and possibly collect some money against a reporter who's getting paid $8,000 a month. Because, if you can intimidate the press, why not? With, crushing financial consequences. On the downside, there's the cost of litigation. He said he would have to start paying legal fees right out of the gate, which I found to be strange, because in my personal experience, these kinds of cases are handled on a contingency fee basis, meaning that the lawyers get paid out of what they collect on behalf of the client. He didn't explain why he couldn't find an attorney to take this on a contingency basis, and why he would have to be paying attorney's fees right out of the gate. That's not my personal experience. It could cost six figures in legal fees. It could take 12 to 18 months. It would probably take closer to 2 years, actually. It would be stressful for him. He's not generally litigious. It would be time consuming. Well, that's why you hire an attorney to do this work for you. He wouldn't be handling the litigation, which he said would take him away from his show, which would take him away from his newborn child at home. That's why you hire an attorney. And he was like, would this be best for the audience? Would it be best for the show? Should I focus on the show? Should I focus on my newborn? Or should I focus on litigation? Again, that's why you hire an attorney. And then he said, what if I win? I clear my name. Am I going to regain all of those subscribers, which is a net loss of 1,000, less than 0.1% of his subscribers? And he's correct on this next point. The settlements in these kinds of cases are typically confidential as it relates to the dollar amount, not as it relates to who prevailed. And so then he said, I want to hear from the audience. Do you guys want me to sue Taylor Lorenz and Wired, or should I not do that? And so now that we've reached this point, let's talk about defamation. Defamation has two types: libel and slander. Slander is saying something defamatory about someone in spoken word. Libel is a defamatory statement made in like a fixed format. It's in writing, it's printed in a newspaper, it's an online article on the internet, it's in the newspaper, that kind of thing. It's in writing. So what are the elements of defamation that you have to prove? You have to prove that the person that you're suing made a statement about you that was not true. And again, the attorney representing Chorus contacted Wired and said, I want you to include some additions to your article. And there's a note at the end of the article currently, and Wired made those additions to the article, because that's what the attorney representing Chorus wanted. The attorney represented Chorus did not say anything whatsoever about David Pakman or anything in the article about David Pakman. The attorney representing Chorus was completely fine with every single thing that this article said about David Pakman. So you have to prove that a statement was made that was untrue, that is capable of being proven false. Doesn't look like we have that here. David Pakman's was very non-specific in his 10-minute long video as to what specifically in the article about him is false. Very vague. Then you have to prove that the statement must be communicated to at least one other person other than the plaintiff. Well, it was published online, so check one for prong number two. You have to prove that the plaintiff, David Pakman, was clearly identified in the article. he was named in the article, then you have to prove that the statement that was made that was false has harmed David Pakman's reputation. Well, again, that takes us back to that first prong. What specific statement about David Pakman in the article was untrue? None, according to the attorney representing Chorus, who contacted who contacted Wired and said, I don't have any corrections. I would just like you to make the following additions to the article, which Wired did. David Pakman is a part of Chorus. The attorney representing Chorus, when he contacted Wired, did not say to them anything at all about, you said something untrue about David Pakman. So we're still kind of stuck on that first prong. But item number 4 is that you have to prove that that statement that was made that is false caused actual damage to the plaintiff's reputation. Well, according to David Pakman's own video, he lost less than 0.1% of his subscribers. So what's that damage there? What's that harm? Assuming that you can meet the first prong, that a statement was made that was untrue, that is capable of being proven false. David Pakman did not identify any specific statement in his 10-minute long video that was false. He just said it had misrepresentations. The article had misrepresentations. Last, fault, 5th prong. The defendant must have made the statement with some level of fault, negligence, or actual malice as it relates to public figures. Which brings us to the last part. Negligence only applies to private individuals, people who are unknown to the public. David Pakman is very well known to the public. That brings us to the Supreme Court case of New York Times versus Sullivan. In New York Times versus Sullivan, it is a 1964 Supreme Court case which imposed, it was a case that involved the press, and I think it was a police chief, if I'm not mistaken. A police commissioner in Montgomery, Alabama, had sued the New York Times for inaccuracies in an article that the New York Times had written about him. But the Supreme Court was like, he's a public figure in this community. He is known to the public. And so that's when the Supreme Court came up with what's called the actual malice standard. When a public figure is suing the press or the media or a reporter, they don't have to just meet those original prongs of there was a false statement that was published to a third party that identified the plaintiff and caused harm to his or her reputation. But when it's a public figure, the Supreme Court said that you also have to prove that the defamatory statement was made with actual malice, intent, meaning that the reporter knew that what they were saying about this public figure was false. They knew that statement was false before the article was published, that it was made with knowledge that it was false with a reckless disregard for the truth. And the reason that the Supreme Court came up with that actual malice standard was to protect free speech and a free press. Because otherwise, any public figure that the press said something about them that they didn't like, they could just sue them for defamation and just have to deal with those first 5 terms, those first 5 prongs. So the Supreme Court in New York Times versus Sullivan came up with the actual malice standard. And in this case, that would mean that David Pakman would have to prove that Taylor Lorenz and Wired published false and defamatory statements against him, knowing ahead of time that those statements were false and defamatory. He can't even identify in his 10-minute long video with any level of specificity what statement about him in the article is false. Because the things that he said the article said about him were false are not in the article. So when he talking about the leading defamation attorneys in the United States, and they discourage litigation for the following reasons, he didn't include the most important reason. Under the law, he doesn't have a case. He doesn't have a case. He cannot meet the actual malice standard. And he also still, to this day, 8 days later, has failed to produce his contract with Chorus. He has failed to produce evidence of his payment arrangements with Chorus. Is he being paid? He said he's not being paid to create content. Is he being paid for something else? Is he being paid to be a mentor to these other creators who are coming in with 50 or 100,000 followers, who need the guidance of someone like David Pakman, who has been doing this for 15 years? He never said that he's not being paid by Chorus. He just didn't say what he's being paid for. He said what he's not being paid for, creating content, but he didn't say if they're paying him or what they're paying him for if it's not for creating content. So in this whole 10-minute long video, David Pakman left out the most important thing that I'm almost certain he heard from these top defamation attorneys in the United States who got great big verdicts that he met with, that he will not be able to meet the actual malice standard set forth by the Supreme Court in New York Times versus Sullivan, which would be required of him as the plaintiff in order to win a lawsuit against Taylor Lorenz and Wired. He can't win. That's why he's not going to file a lawsuit. That's why Brian Tyler Cohen's not going to file a lawsuit. That's why none of the other creators associated with Chorus who have any level of notoriety whatsoever are not going to file a lawsuit. I said that like last Thursday. They're not going to file lawsuits because they can't meet the actual malice standard of New York Times v. Sullivan. Period.